Expulsion is the most serious punishment available within the school system, and it can have long-lasting consequences for expelled students, both for their education and for their lives more generally. Although school boards deny it, most expelled students have some identifiable characteristics. They are more often racialized, have special education needs, are socially awkward, nerds, geeks and such, have been in the care of a children's aid society, or a combination of those factors. In short, they are the most vulnerable students, but none of those are good reasons to expel a student. Alternatively, principals want kids out of their school if there's even a hint of sexual impropriety, which raises a lot of questions about injecting school discipline into student social dynamics, especially amongst teenagers. I'm John Schumann, a lawyer with 20 years experience practicing education law in Toronto. In this episode of the podcast, I will explain the legitimate reasons for expelling a student. Because without such a legitimate reason, students and parents should fight the expulsion. I will start by noting that it makes a big difference whether the student is in a publicly funded school or a private school. Public school students have more protection. Private schools can kick out kids for any reason that is permitted by the contract with the parents. And many private schools have contracts that basically allow the school to kick out kids without a good reason. Private school contracts can also require the expulsion of students for activities that had nothing to do with the school. In an earlier episode, I went over the importance of those contracts and parents knowing what is in them. Only if the contract refers to the Education Act sections that apply to discipline in public schools will the rest of what I say apply. Ontario's Education Act sets out what behaviour can lead to expulsion and a procedure for dealing with whether a student should be expelled. Again, this law only applies to publicly funded schools unless a private school incorporates some of or all of this part of the Education Act into the contract. The Education Act does not allow school boards to expel students for any behaviour. First, even if a student behaves badly, there must be some link between the behaviour and the school. Section 310, sub 1 of the Education Act says a student can only be expelled for something the student did while at school, while engaged in a school-related activity, or in circumstances where engaging in the activity will have an impact on the school climate. Obviously, principals and teachers can discipline a student for anything the student does at school. It is also an obvious extension that they can discipline a student for things the student does on a school field trip, at school sports activities, while participating in a school club or a school dance or other school event. While the school or the school board organizes an activity, students are subject to the same discipline as they would face in the classroom or in the schoolyard. Some principals make nefarious use of that third criteria, activities that impact the school climate, to expel kids for activities that have nothing to do with the school. Even events that happen far away from school during school breaks that do not involve students of the school. The principal says that such behavior would impact school climate, but in most cases that is not true. To impact the school climate, not only must an activity have some relationship to the school, such as other people from the school being impacted or involved, but if the behavior does not occur at the school or at a school-related activity, it must have an impact on many people at the school. A person's behavior can't impact the school climate just by affecting one person. It must impact many people at the school and impact them in a way that, affects the entire climate of the school. If a lot of people connected with the school do not even know of the alleged behavior, then it probably did not affect the school climate, and so a student cannot be expelled for it. Where a student's behavior did not occur at school, nor at a school-related activity, nor impact many people at the school, then the student and the student's parents should not agree to the expulsion, and instead should argue this point at an expulsion hearing. And if the school board still expels the student, then the student or the student's parents should immediately file an appeal of the expulsion with the Child and Family Services Review Board, which hears appeals of student expulsions. To explain that a bit more, here's an example taken from some expulsion appeal decisions. Dealing drugs at school is grounds for expulsion. Dealing drugs away from the school to people who do not go to the school is not a grounds for expulsion. Dealing drugs away from the school, but where some of the customers happen to be students, is not grounds for expulsion. Dealing drugs away from the school to students at the school after advertising at the school where to get the drugs is grounds for expulsion. There are other behaviors that can have stronger or weaker links to school. Dealing drugs is just one example to illustrate my point. The more connected an expellable offense is to the school, the more likely the student can be expelled for it. And the less connected to the school, the more difficult it will be to expel the student. Not everything a student does at school can get the student expelled. There's a relatively short list of offenses that can get a child expelled from public school. Those offenses are: first, possessing a weapon, including possession of a firearm. Second, including a weapon to cause or threaten bodily harm to another person. Third, committing physical assault on another person that causes bodily harm requiring medical treatment. Fourth, committing sexual assault. Fifth, trafficking in weapons or in illegal drugs. Sixth, committing robbery. Seventh, giving alcohol or cannabis to a minor. 8, repeated bullying. 9, bullying that creates an unacceptable risk to the safety of another person. 10, threatening bodily harm, swearing at a teacher or a person of authority, committing vandalism or bullying where the behavior is motivated by bias, prejudice, or hate. 11th, other behavior that the school board's policies say must result in an investigation into whether the student should be expelled. With respect to that last point, school boards have tried to open up what they can expel students for by putting in a policy that expulsion must be considered for any behavior that impacts the moral tone of the school. However, expulsion appeal cases have held that, like activities that impact the school climate, to impact the moral tone of the school, the behavior must have had an impact on many people, students, and teachers at the school, not just one, two, or a few. Impacting the moral tone of the school means exactly what it says. It must impact the entire school, or almost the entire school, to change the tone at the school. If a student's behavior does not fall into one of those 11 categories, it is not an offense for which a student can be expelled. A student cannot be expelled for just coming to school drunk or high. A student cannot be expelled for hitting someone unless that victim needs medical attention or it is an act of bullying and the student has already been suspended for bullying. Vandalism that is not motivated by bias, prejudice, or hate is not an offense that can get a student expelled. A parent or student should not agree to an expulsion unless the student's behavior is on the list of behaviors that can get a student expelled, and should go to the expulsion hearing or appeal the expulsion if necessary. It may not be appropriate to expel a student who has done something that is on the list of expellable offenses. In a document called Policy Program Memorandum 145, the Ministry of Education has told school boards that expulsion should not be the first discipline that a school board uses against a student. Instead, school boards are to focus on early intervention strategies to prevent unsafe or inappropriate behavior. From there, schools should use progressive discipline, using the least intrusive discipline measures first, and only employing more severe consequences when lesser discipline does not work. Even then, discipline must be corrective and supportive, not punitive. In addition, the school is required to actively engage parents in the progressive discipline approach. It is not appropriate to expel a student where the first time parents hear that their child has behavior problems is when they get the letter that the child may be expelled. Where a school has not used progressive discipline, the parents or student should challenge the expulsion at an expulsion hearing or do an appeal. Consistent with that approach, Ontario law says that it is not likely appropriate to expel a student where allowing the student to continue in school does not create an unacceptable risk to the safety of any person at the school. There are additional things that can make expulsion an inappropriate form of discipline. Ontario law makes several of them very clear. Expulsion may be inappropriate under Ontario law where the student cannot control the behavior. The student cannot understand the consequences of the behavior. The behavior was related to the accused student having been harassed because of his or her race, ethnicity, religion, disability, gender, or sexual orientation. The behavior was the manifestation of a disability identified in the student's individual education plan or IEP. The expulsion was the result of a failing to provide appropriate accommodation to students' identified special needs, or where an expulsion will make the student's behavior worse. In addition, since discipline is supposed to have an educational purpose, that is, it must help the student's education, it can be inappropriate to expel a student where the expulsion would have a negative effect on the student's overall long-term education rather than supporting it. That means that an expulsion that is intended to encourage a student to drop out is not appropriate. In previous episodes found at www.schumannlaw.ca, I have gone over what to do to challenge an expulsion, both at the expulsion hearing and in an appeal. There are grounds on which an expulsion can be prevented or overturned. But if any of the factors that I just described make an expulsion inappropriate, then the parent or student should fight the expulsion. If you need more help doing that, you can find more information at www.schumannlaw.ca, or you can speak to an education lawyer to get advice and to get specific guidance to your situation. Note that Ontario law is very tough on bullying. In a previous episode, I went over what public schools are required to do about bullying. The first time a student bullies, they can be suspended. After a student has been suspended for bullying, if that same student bullies again, the principal is required to suspend the bully from the school for up to 20 days while the principal considers expelling the bully. There is not much sympathy for bullies when they have tried to fight in suspension or expulsion from school. When a student's activities do not meet the criteria that I just set for them to be expelled, some principals and other school officials have tried to use another power called exclusion to prevent the student from going to school. A principal can exclude or deny access to a school to any person whose presence is detrimental to the safety or well-being of anyone at the school. So some school officials have tried to use that power to kick out students who have not done anything that meets the criteria to expel them. However, the Ministry of Education has directed that exclusions are not to be used as a form of discipline, and Ontario law does not permit students to be excluded from the school in which they are enrolled, just other schools where they do not have classes. So this is not something that school boards can do to get rid of students. I covered exclusions in a previous episode as well. While it may be possible to expel private school students for anything, things are different for public school students. They must have misbehaved at school, at a school-related activity, or in a way that impacts many students at the school. In addition, there are only 11 types of misbehavior for which a school board can expel a student. If the student did not commit one of those types of acts, they cannot be expelled. And there are some special circumstances where even if the student did one of those types of behavior, they still cannot be expelled. If a school is trying to expel a student improperly, the school and parents should fight the expulsion. There are procedures for doing that and for appealing expulsions. If you need help with that, either visit www.schumannlaw.ca or get in touch with an education lawyer. There are several at my office you can reach by calling 416-446-5847. If you need more information about education law and children's rights, or information about family law issues, check out www.schumannlaw.ca. There are thousands of pages of legal information on that website, links to additional education law resources, and links to reach my office to meet with either me or one of my colleagues. You can also set up an appointment to speak to us by calling 416-446-5847. It is always best to get a lawyer who can give you expert advice that's specific to your or your child's situation. In addition to my website, keep up to date on family law and children's law issues by liking my Facebook page, following me on Twitter at @SchumannFamLaw, and finding me on LinkedIn. Of course, please also subscribe to my YouTube channel and hit the notification bell to make sure you stay up to date. Get the audio versions of the Ontario Family Law podcast on all major podcast services such as Apple Podcasts, Spotify, Google Podcasts, Amazon Music, and many more. Or you can get all the episodes at www.schumannlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.